Good afternoon and welcome to today's Euractiv event together with VDMA. We're asking the question today, how can we ensure fair industrial data sharing terms within the framework of the Data Act? Now, the Data Act was a long-awaited piece of legislation that aims to set out a way in which data can be shared within the context of the Internet of Things, or connected devices, if you like. And the whole idea is to unlock the potential of Europe and its innovative machine learning possibilities, and to work out ways in which the data that we're all generating and that businesses are generating can actually help drive growth. Now, we're going to talk about what that means for different sectors, because it is certainly aimed at a business-to-business community. That's what people are viewing it as. But there are some consequences that we may not have foreseen, and we're going to talk about those and what might be the impact in the real world as this Data Act, as it stands, is implemented. To talk about that, I'm very pleased to welcome our representatives from the European Commission: Antonio Basson, Legal and Policy Officer in Data Policy and Innovation within DG Connect in the European Commission. Joining us from the European Parliament, Pilar del Castillo Vera, MEP, member of the ITRE Committee, and of course, rapporteur on the EU Data Act. Kieran Nuthi is a Senior Policy Analyst at the Centre for Data Innovation, and Thomas Mann is Chief Information Security Officer for K-Businesscom and Heinzel Group. Thank you all very much for joining us. As I mentioned at the outset, this was a hugely anticipated piece of legislation. Antonio, perhaps you can tell us a bit about its coming about, how it arrived at the state we are seeing it in today, and give us a little bit of a history and the aims of the Data Act.
Sure, yeah. Well, first of all, thank you very much for the invitation. It's really a pleasure to be here. So as you actually well indicated, we've been working on the Data Act for quite some time now, for a few years, and it really comes at a very auspicious moment, because it is, as it was announced in the European Strategy for Data that was published by the Commission in February of 2020. Our objective is to ensure that Europe becomes a leader in the data economy, and indeed to harness this potential that is possible with the ever-increasing amount of industrial data. And so, as announced in the European Strategy for Data, we are moving forward with two pillars, which would be, and they go hand in hand, which is this legislative approach, and also the financing of data spaces, also very important to keep in mind. And this is to ensure that we can handle data in our European way. And with the Data Act specifically, we have found the right balance between opening up more data, but also preserving the incentives for continued investment in data generation and data technology. Now, we are currently facing in the data economy a new type of challenge, because in the past, when someone bought a product, it was quite simple. You bought the product and that was the end of the story. But nowadays, with the advent and the emergence of Internet of Things and connected objects, there is data that is being generated by the use of said object, and that data has value. But it's not always clear who can use that data. So the Data Act does precisely that. It aims at clarifying who can use what data and under which conditions. This is the first chapters of the Data Act deal with this issue specifically, but not only. The Data Act also deals with improving cloud switchability, also making more data available for the public sector. It also deals with data interoperability in the Union. And there's a very important element as well with regards to fairness, specifically in business-to-business data sharing, that will help SMEs improve their negotiation position. So overall, if I can just conclude this by saying that the main objective of the Data Act is really to ensure that there is a fair allocation of the value of data across all parties, across all actors in the data economy. So really, that is perhaps just to bring everyone to speed on the Data Act, and I really look forward to the discussion.
Thank you very much, Antonio. Pilar, as Antonio said, it's a quite auspicious moment. It has taken time, but Europe really needs this at the moment. We're trying to build back better out of a pandemic and various other crises that we see happening. So really harnessing this hugely valuable resource is something that we have to do. and by some estimates, around 80% of industrial data is not used. I mean, that is a huge untapped potential resource. Do you think the Data Act is the right instrument to get us there?
That's for me. Okay, well, first of all, good afternoon. And also thank you from my side to Euractiv for giving this opportunity again, once more, to tackle the Data Act, which can be so much important in the end. Well, first of all, I think I should mention that we all agree that data is fundamental for the European digital economy. I'm not saying anything new, but sometimes you need to underline very basic things. And at the same time, data collaboration within and across Europe's industries will be key for future innovation and economic growth. I believe that the Data Act, in that sense, can be a game changer if it enables easy access to an almost infinite amount of high-quality industrial data. We must always, for starters, take into account that this is a regulation that will be applied at the European level, avoiding the market fragmentation that sooner than later, I would say, could emerge from individual and national legislators. Being the main aim of this panel to focus on the potential impact of the Data Act on manufacturing SMEs, I will not enter into the B2G chapter of the proposal, but I would like to highlight that I have excluded SMEs from the obligations of shared data free of charge with public authorities under the concept of exceptional, or the category of exceptional circumstances. Then, regarding the IoT chapters of the regulation, I must underline that the main principle is that the user must have access to the data produced by the connected products and related services, and consequently, to be able to share it. However, this is a statement that, as you can imagine, is easier to say than done. The Data Act might affect businesses differently depending on products they manufacture or their role in the aftermarket. I believe the starting point must be to clarify what IoT data falls under the scope of the obligations of the Data Act. I have to say that this was one of the main concerns. There were a few more important concerns, but just a few more. But this was the first one when I start to have a chain of views with a huge array of stakeholders. The definition of data we are talking about, what is in, what is out, needed a further clarification. So in my report, I introduced what I think at least was a very basic clarification added to what the Commission has proposed, such as what is in scope. In scope are data in raw form as well as prepared data. That is data cleaned and transformed prior to processing and analysis. In other words, data that is pre-processed for the purpose of making those data usable without, however, reaching the stage of deriving or inferring insights. So what is out? What kind of data is out of the scope? Out of the scope are derived or inferred data. This means data resulting from software or hardware processes that calculate derivative insights from the data generated by the use of a product. This was very useful in terms of continuing with the debate and continue with the rationale of all this, That was the starting point to clarify things related to data holder concept, to IP and trade secret protection, and different aspects. I leave it here, this distinction. Lastly, since we are focused, and I want to come back to the SMEs, to the focusing the debate on manufacturing SMEs, I must stress that I also have proposed to enlarge the exclusion of the data sharing obligations of Chapter 2 to medium-sized enterprises. Finally, I like to say that the data is quite groundbreaking. Consequently, the starting point of the discussion should be in this particular area, the exclusion of the SMEs. Now will be the time to study if the SME concept should be absolute or if further clarification with regards, for example, market power should be introduced, because that's another way of defining who is in, who is out in terms of SMEs. To finalize, I would like to add that I plan to, and I am in that process, fine-tune the report, and I still working in two main aspects, which are the pillar in some way of all this, which is the concept of data, as I mentioned, still trying to clarify in addition, and as well a more future-proof concept of data holder, which is another pillar of the Data Act. So thank you very much. I leave it here.
Thank you, Pilar. You've touched on all those big main points that we are going to come back and talk to you about in a little more depth. Indeed, data holder is one of the areas we want to look at how we're defining that and what that's going to mean in practice. Keir, obviously the aims are very laudable. Are there any downsides? And it's not a one-size-fits-all, although this will be across European law, across all of the different member states. So where are there gaps? Where are there bottlenecks? What should we be looking out for?
Hi, thank you so much for having me, and I'd love to get into that. I think it's important when we're talking about the data economy that we talk about how much it's grown as well, so we can just get the sheer scale of what we're talking about. By 2030, the EU data economy is going to cross the €1 trillion threshold, and it's grown on a year-over-year rate for a while now, accounting for almost 3.6% of European Union GDP. That's why the Data Act is so critical. It's going to help boost the data economy by creating a clear framework for the internal market. Now, while it's clarifying what institutions can access and share data generated for customer use from connected devices, and it is stated to benefit European SMEs and consumers, there could be some revisions to make that even stronger. To ensure what the Data Act says on the tin, I think there need to be some revisions to reduce barriers to entry for businesses, clarify legislative interactions, because I do worry that for businesses of all sizes, not just SMEs, they're more likely to focus on compliance and not innovation from the very beginning of the product or services design phase, which in comparison to international competitors might burden the EU data market in a way that's unintended. And I would love to see more clarification in that space to make sure that the Data Act doesn't cause these businesses to face capacity constraints or stifle their own innovation or failure to launch their connected devices. I think the focus on how to incentivize small and medium-sized enterprises is a strong one, but size-based distinctions from my research feel to be a little arbitrary, and businesses of all sizes, including SMEs, are going to focus on complying with the entirety of the Data Act, which might make it harder for them to scale up and grow. We already see this with European SMEs struggling to get aboard the data economy. Only about a third of them have data sharing in their strategy, and when surveyed, say that they'd redirect resources towards compliance and away from innovation when faced with similar restrictions on their data sharing, regardless of how small or large they're getting. If we can find a way to reduce that compliance burden in comparison with international regulation, I think the EU could be incredibly enticing for productive SMEs, but that's just a clarification in the Data Act that could be made to make sure that we have a stronger EU data economy and a stronger EU data market moving forward.
Thank you, Keir. Thomas, dealing with the security of data is a very hands-on job day to day. Tell us about your experience and what you think the Data Act might mean.
Yeah, as I said in advance, I'm talking from the practical point of view to you. So my real life consists of many situations where I have to share data, where I have to secure data. And especially in the area of industrial machines, where you have a lot of machine data, where you have the obligation to get data out of production environment, to process the data, maybe use the help of cloud services to optimize the data and optimize the maintenance cycles of your machines. I think it's a big chance that we have with the EU Data Act, because I think it will lead to more transparency. And transparency means, if I compare to the data privacy, that there is an obligation for example, for a machine producer to clarify what kind of operating data the customer can expect, which data could be processed in the customer environment. And it will also lead to more transparency in the office when the machine producer gives the customer the obligation to optimize the maintenance cycles, that there is a clear picture about what is this data used for, how it is secured, how can we make sure that there is no other use case of the data which is not in the intention of the customer. So these are all points that have to be considered. And I would like to point out that the state-of-the-art processing of the data is one of the most important things, that the data is confidential, that the integrity of the data is kept. That's one of the most important things. And before we heard that the internal processing data, which a machine needs to run, this is something where the IP of the manufacturer should be kept, that the advantage we have on the market, on the international market, is not in danger. But the interface, the operating data interface, should be clearly specified, that all the use cases which can be given on that kind of data are transparent to the user of that system. And I very often have the situation that producer of machines come to us and say, okay, we can optimize the maintenance cycles. Please give us that kind of data. And the problem I have very often is that I have to specify the interface. If there are systems which have a communication inside the production environment, that I have to have a clear border to make sure that there's no interference when I exchange data.
Well, thank you, Thomas. To come back to you, Antonio, I mean, Thomas alluded to it there. He mentioned IP. We've also got legitimate concerns from businesses around trade secrets. I mean, what sort of safeguards are there? How much was that taken into consideration for business of all sizes, even before we get into the specific question of SMEs?
Yeah, so this question around trade secrets and IP rights was actually, we discussed it at length with colleagues in the Commission, specifically with colleagues in DG Grow that deal specifically with this issue on trade secrets, for instance. And perhaps it's useful just to take a little bit of a step back first and consider here what we want to do with the Data Act. With the Data Act, we want to spur innovation. And it is stated quite clearly that the Data Act does not affect in any way, shape, or form existing legislation at union or national level dealing with trade secrets. But since a company can unilaterally claim that any data is a trade secret, this could seriously hamper the effectiveness of the Data Act, specifically with Article 4 and 5, because it would essentially say that it would be impossible for the user to get access to this data because simply due to a unilateral claim that this data could constitute a trade secret. So actually, what is available for a data holder to protect itself? So of course, besides the legal certainty that is already provided for in legal and national law, the data holder can actually sit down with a potential user or potential third party and agree on contractual, technical, or organizational measures that have to be taken to ensure that this protection of the trade secret actually continues. And this practice of exchanging trade secrets is not something that is new with the Data Act, not at all. It's quite a common occurrence for companies, for example, to sign NDAs and then exchange this trade secrets. It's really important to understand that with the Data Act, we're not talking about with specifically Articles 4, 5, and 6 even, we're not talking about an open data kind of situation. And so many of the provisions that, many of the examples that Thomas was bringing up could be very interesting practices that would be put in place to ensure that this data is indeed continuously and adequately protected.
Thank you. Let me bounce back to you, Keir, and get your perspective on this question. What do you think is the right direction of travel for issues around trade secrets, data protection, and as Antonio has suggested, these NDAs that people might use to get around some of the problems?
I think it's really great that the Act explicitly states that it shouldn't affect these rights. But I do think that there is a way that there could be more clarity around how compliance with these restrictions will be monitored under the Data Act. When I was researching and looking through the Data Act with regards to trade secrets and intellectual property rights, I focused a lot on what data holders have as like an ability to prevent uncontrolled sharing of their data. I think that is a place where the Act could have quite a lot more clarification, entirely because data holders who do really want to keep their trade secrets and their IP secure might be disincentivized from data sharing altogether if they don't have this clarity, which from an international perspective, I fear that if there's not enough clarity around this area within the Act, it could steer businesses who don't have the ability to staff people for compliance from launching an EU data economy, which would be, I think, the opposite of the ethos of the legislation. So because of that, I think just a little bit more clarity within the Act itself could be quite helpful in navigating how data that is subject to trade secrets can be disclosed moving forward according to the Act, if that makes sense.
It does. Pilar, I'd like to come back to you. We're actually already getting quite a lot of questions in from our audience, so we'll try and get through a few of them. Carolina Walczak from MasterCard is asking, could you expand on how to ensure alignment between B2B or B2C provisions in the Data Act and existing sectoral legislation that already deals with access to and sharing of data, for example, PSD2 and European data spaces? Just a little bit, if you could focus on where there are overlaps and what might be useful for companies to know.
Sure. Okay. First of all, you don't mind, I would like to introduce some clarification on some of the points that was introduced by the previous speakers. In the case of the clarification of in terms of GDPR, this is all personal data are referred to the GDPR. And with this Data Act or without this Data Act, all personal data must be under the umbrella of the GDPR. So in this sense, there is nothing new. I mean, you have to just behave as it is. You would do it regarding the GDPR in any case, even if the Data Act is not in the scenario, in the scene. So that's on the one hand. On the other hand, in terms of trade secrets, I am in the same line that the representative Antonio from the Commission, but I think that we have a definition of trade secret defense, which is the outcome of international trade agreements. We cannot modify this concept. We have also to take into account that the review of the directive for trade secret, the European one, is not going to take place till 2025. So the key point is data. You can say data, what data it is in, what data it is out. And so starting for starters, I mean, the personal one are apart, because you have to apply the GDPR, which I insisted in any case you have to do it. If it's not under the Data Act, it doesn't matter. All personal data, that has to be derived to the GDPR or to be applied the GDPR. And then, since the difficulty is to change the concept or say, okay, some of the trade secret can be, some of the trade secret is not. So the way to do that, if we want to do this, to have this proposal to usable and applicable, we believe that all these amounts of industrial data that are under use, 80%, so I think you mentioned at the beginning, according to the Commission, and this is, we want to open all this for innovation and give new possibilities to the industrial data, to enter into action and reinforce the assets of the competitiveness of the European Union economy and more precisely our industry. So this is something that we absolutely need. Not try to go on with something like that, is to be in the stage of business as usual. I think more than ever now, we cannot be in the business as usual anymore. I mean, in any respect we can consider. So this is because, in my view, this is so much important. Imagine the number of startups, of innovative small companies, and not only that, in the aftermarket you find many services and many kind of businesses that they can really take advantage of it. Having said that, I think the only way is to focus on the concept of data. We have proposed a way, which is the way of the Commission, with further clarification, and still we can, as I say, fine-tune. But in terms of sorry, because I went to other side. Your question was, can you repeat it me? Because I stay for a long time in the
No
trade secret and the GDPR.
And the question was, how does it work with other sectoral legislations that already deal with access to and sharing data? Such as PSD2, this side of thing, rather than GDPR, which was a question, Pilar, you actually anticipated another question and answered it already.
No, yes, sorry. Maybe because I have to leave, well, still in half an hour, so we have plenty of time. This is a horizontal, as we know, regulation. It's trying to set the principles that should have their own specification in the different sectorial regulation that the Commission either has already produced. We have to think in the health sector one, which is now in Parliament. We have to see in the announced that the automotive sector will be in place, make it public by the Commission and send it to Parliament in a few months, and so on and so forth. So the idea is to have general principles that can be applied to different sectors. For example, in terms of data, these general principles can be applied to all sectors. These principles of the data that are in the scope and the ones that are out of the scope. In terms of data holder, which is one of the things more complicated, because the data holder is not necessarily the one that developed the product, such as let's say the manufacturer. It could be, the data holder, one specific part of the product can be in other hands. in other companies. So the data holder is another. Even you have a smartwatch, you have the applications, and imagine you go to any of those famous companies that they have smartwatches. You say, okay, I want the data from this and this and this application, my data on this. So you cannot attend that. So the data holder should have a definition, principles, a definition in that sense, principles that can be applied reasonably to all kind of sectors. So this is because the difficulty, we are still working on that. I think the concepts of legal and concepts to be the one that has legally the data, and they have de facto the possibility to get the data is important. But something else, we are working. I don't want to really go further with this because this is something that requires every day we are working with many, also together with the Commission, trying to also push for clarify more and more this. And in terms of the application to the different sector, that is, I mean, this is a framework that should be applied to be able to be applied to all sectors, and not forget that the same one that produced the first version of and developed the idea of this horizontal regulation is the same institution that is working with the sectorials. So the name is the Commission. So they are not going to contradict, themselves in itself in the idea of, okay, this is a general one, and then everything is contradictory with the sectorial one. No, this is something that it is interrelated from the very beginning. So it shouldn't have a contradiction with that.
Well, thank you. Thomas, a couple of questions for you. First of all, do you agree with this in terms of this sectoral, horizontal versus sectoral approach?
I'm very happy about the discussion. Yeah. I would like to bring in that I see a big chance for the industrial industry in the Data Act, because the Data Act brings more transparency. That's one of the main points. Why I did bring in the GDPR law was because of the fact that encryption and state-of-the-art technology, which is linked to the processing of personal data, is something which would also help in the Data Act. The more data you exchange, the more data you process, the more you have the obligation to secure confidentiality and integrity. And when we are looking to the development of new industrial systems, if you specify the data which could be consumed from the customer, so the plant where this industrial system is working, the better it is. So it's a big argument for selling that machines. So that transparency will bring up a new data economy. And I think that's exactly what's the intention of the law. Why I was bringing in the IPR statement was that it's very important to enforce the machine producer to give the information what kind of data could be processed out of the machine on the customer side. And the more transparency and the more data which could be processed, the more value is generated out of that machine. And this is something which is really important. And on the other hand, if you have that data and you have a service which is processing that data afterwards, so the operational data, which is processed afterwards, there should be transparency what is done with that data. So the processing should be transparent to the customer. So machine, on the other hand, delivering data, and on the other hand, processing in the cloud for whatever purpose.
Well, let me, Thomas, build on that, because we have a question that I think might be relevant to you as it concerns cyber resilience and cybersecurity objectives in general. Is there a correlation, Karina Stan is asking, for example, the scope of mandatory data portability includes diagnostics data, which raises cybersecurity concerns. Is that something you feel?
Diagnostic data are part of operation data. So if you have a misfunction of a system and you have on the operating data stack information which gives you the possibility to analyze why this machine is not doing the right thing at the moment, this is also part of transparency. So the data stack, and I fully agree, it's necessary to have that kind of data to do a proper operation, and to get the hint, if something is working not properly, you should have the possibility to get that kind of data. But this is part of the definition of the operation data stack.
Keir, we have a specific question for you from the European Digital SME Alliance, asking, could you elaborate on why size-related exemptions are arbitrary? How can we create a thriving digital economy, if not by easing the regulatory burden of startups and small businesses? Obviously, that's from the SME Alliance, so they have a strong, keen interest in this.
I think it's hard to explain in just a few sentences, but I'm going to try. For the exemptions within the Data Act, I think there is a clear understanding that we need to be promoting how to get SMEs to competitive, innovative, and like globally competitive. I do think that is a clear understanding of why there are carve-outs, but carve-outs aren't necessarily the long-term solution, which is almost entirely why I believe there's a different approach that the Data Act could have. The carve-outs, while they do allow the space to succeed in the short term, the Data Act does focus on finding out data sharing and how to comply with the legislation from the design phase of a product. So from the beginning phase of any connected device, conception, design, etc., of these products, businesses of all sizes are going to have to focus on eventually complying with it. The reason I say that is because it's a matter of wanting to grow. So in the sense of, if companies desire to scale up in the future, they're going to focus on dedicating staff to compliance, increasing their expenses, and other practices to comply with the data sharing standards of the Data Act, because from product conception and design, you're going to want to figure out how to make the data required easily accessible upon consumer request. I worry that much focus on how to get to data sharing can come at the expense of product quality, because it can force some companies to focus on either re-engineering their products that they currently have if they want to scale up in the future, or focus on compliance as much as innovation when they're starting their business, which internationally might not be as competitive as we want.
Thank you. Antonio, let me come back to you. There's several questions, as always, for the Commission when there's a new act on the table. This first one is from Eurogeographics, asking, how will the Data Act affect public sector data holders, particularly holders of high-value data sets, such as geospatial data sets?
So thank you for the question. This isn't really something that is going to be dealt with by the Data Act. It's actually under the Implementing Act on High-Value Data Sets that will be adopted under the Open Data Directive. So seeing that this is indeed data that is, of course, of very high value, specifically geospatial data, of course, although it wouldn't be under the Data Act that this data would be made available for SMEs. Or really for anyone, because it is open data, but seeing that SMEs often have such difficulties in getting access to high quality data, getting this data from public sector, and not only geospatial data, of course, there are multiple categories, but that will be to the benefit of, in particular, SMEs to drive their innovation. And on that point, actually, I would like to just come back here a little bit and think about this SME exemption question, because I think it is extremely pertinent, not only due to the discussion so far, but also with the title of this event, really. So it's quite hard to defend a position where this access to data by a user of a product to the data holder of that product, it's quite hard to defend that position, that it shouldn't take place, because after all, the user is a co-generator with the data holder of the data, because without a user, there is no data, without the use of that product, of course. So it really doesn't matter how great the sensor is, you really need to have both actors, the product and the user. So when we're talking about the portability right, we're really talking about a market mechanism, because the manufacturer of that product will be quite intuitively in a better position for various reasons here. Because first of all, the user will have to use the portability, will only use the portability right when they cannot find a service with the manufacturer directly, or they actually are unhappy with the manufacturer's service. And then also there is a question around the fact that the user has to overcome its, well, inertia, right? The user will have to actually get in touch with a third party, or a third party will have to convince a user so that the user activates that right, while the manufacturer, because they are placing the product on the market and can offer these related services at the same time, they really don't have that same cost as the other two entities. So, and also very important to remember here is that this portability right works both ways. So a data holder, which might be a manufacturer, might have to make their data available, but they can also request data to be made available to them. So really, this is the main point of the Data Act is not really to just improve competition and to improve this higher quality of IoT objects, but it's also and specifically to give digitalization and to give the data-driven economy a push. And so manufacturers and data holders should focus on not only the products, but also developing good services. This will be the future of the data economy, will be based on how exactly can you provide services to potential users that aren't necessarily the ones who bought your products. And so since the data will be the key infrastructure for this future, we shouldn't expect data holders to just hoard data and essentially monopolize their data so that no one else can use it. This is quite philosophically speaking, and even economically speaking, it would be working against the interests of fully achieve the objectives that we are trying to put here on the table. And just looking at, for example, other sectors, which I think is quite interesting. Someone mentioned earlier a question about the PSD2. And in that regard, the banks were quite reticent towards allowing for greater data sharing. But now they have embraced that lesson about how this increased data sharing can actually work to the benefit, to their benefit. And so the manufacturing industry can also learn from here. And so it will be something that will be potentially a domino effect throughout various different sectors in order to improve horizontally our economy. I'll stop there.
I'm going to give you a quick follow-up question because it's quite a short, from Giedre Galkauskaite. Should we understand that data generated by the use of smartwatches are subject to the Data Act? I think I've broadened that out into how is it decisions made on what is and isn't within the scope in terms of devices?
Yes, so this is a very good question. So let's essentially, we try to define it like this. The products that are in scope are the products that are essentially generating or collecting information about their use or about the environment. And so in this regard, we can include a vast array of different technologies, such as coming from, I don't know, washing machines or factory equipment, health devices. But then when we're talking about the exception to that general principle, we have to think about situations where there is, for example, the primary function of this object is to display or play content. So, and usually this is actually highly processed content that entails quite complicated analysis with regards to the user-generated digital content that might actually be protected via multiple layers of copyright or intellectual property rights. And in that regard, it's a much more complicated unbundling of how the rules for actually the user to get access to that data would work. So right now, that would be the split. It's essentially ones that they display or play content, or also the ones who process, whose primary function is to process or store data, such as, for example, a laptop or a data processing service. So cloud processing services, for instance. These would be out. A smartwatch, which is perhaps a complicated object because it lies more or less in the middle. However, the understanding is because it has a very strong interaction with regards to monitoring human body movements, for instance, there it has been placed, it would make sense to put it in scope as well. So there will be, this is also very important to understand that this is not set in stone. There is in Article 41 the possibility for a review of these categories. So actually in the future, there might be an assessment if this differentiation is indeed to remain as it is, or if there have to be new types or categories of data that will be included in scope.
Thank you. I think, and I hope that answers the question, because I know this is one that comes up time and again, not just in today's debate, but in other debates and discussions around the Data Act. This deciding what's in scope is one of the big ones. Thomas, let me come back to you again. I wonder, could you perhaps, as we've got a couple of questions that are tangentially or directly related to the questions of design, of product design. And I'd like to get your perspective on what the Data Act is saying about that, where problems lie, what you would like to see clarified as the actual act takes shape. Is there things that need to be nailed down better in terms of definitions or clarifications?
I mean, first of all, I expect that there is a lot of work to do from the design point of view. For example, we have a lot of machine producers within the European Union, so-called hidden champions. So the product life cycle, it takes some years, and if you adapt the data model or if you specify new things, that takes time and that costs a lot of money. So this is one point that the industry needs some time to adapt to that new legislation. And the other point is transparency, that the customer who is buying that product knows exactly what he can expect. And exactly that point means that in existing products, you have to review the data structure, you have to review the interfaces, and from the technical point of view, you need to design the new data structure, and this is effort which needs to be covered by the producer of such products. And in my mind, this will take some time to get adopted. Especially the hidden champions very often are not global players. They are niche producers. They have special products for special purposes, where they are world market leaders. And they need some time to invest in their products, in the interfaces, to fulfill the need driven by the Data Act.
Thank you. Pilar, let me come back to you. There's a lot there that we've been discussing. I don't know if you want to comment in any of that directly, but we've also got some questions for you that are coming in. Agatha Hildago is asking, who and how should we make the distinction between prepared data and derived data? Another question similarly on this same subject, should it be clarified that it's only raw data that we're talking about in scope, i.e. data that has not gone through a process of extraction, aggregation and refinement? If you could expand a bit on those different data types, what they mean, what still needs to be clarified and where, and indeed what you're working on in the ITRE committee in terms of the text.
Sure. I will immediately, but I want to comment on Antonio's last question. You wrote to him, and I to him and Thomas on the time is needed to be implemented and the kind of future redesign and all this kind of thing you need to do to prepare for this data to be applied effectively. So in terms of devices, I think the difficult question, I think it is when you focus on devices, is that, well, we don't know in the future what is going to be the function or what kind of devices. I mean, this can evolve extremely rapidly. And in that sense, it's much, in my view, more efficient and more useful to focus on data. I mean, data can be with one content, another content, with one definition, with one specific features, in, out, but around data, you can really solve better many of the problems you find, from the trade secrets again to the type of devices, for example. But, well, I don't want to stay only in this point. In terms of times that very rightly Thomas mentioned, I think, well, we are in that debate in Parliament. The Commission has proposed 12 months for the application of this regulation. And that is not a directive, it's a regulation, so that should be immediately enter into force in the time we decide that this has to be. And it's going to be debate in Parliament. What will be the final outcome of this period, you know, still is foreseen in Parliament, but the starting point is the 12 months of the Commission, always taking into account that we cannot, you know, spend more time. Many times we can really try to make an effort and going through, you know, in shorter times as much as is possible. You know, as much as is possible, because sometimes from the very beginning, when the Commission starts with the public consultation and even before thinking about this to the final end, I mean, you don't have the problem in place. You have new problems. And then it's a pity, but then you have almost restart again the reflection in order to give answer to new questions that were not there. In terms of the clarity of the data, the question that you mentioned on prepared data and raw data, well, raw data means raw data. Raw data means all the data you have. Imagine, because the audience many times, you know, in my case, I'm not an engineer. You can use examples that can be understandable in a very easy way. For example, you have opinion polls. You have, let's say, 30 questions to 3,000 people. Then you have the raw data. Everyone knows that the raw data is any single answer to each of these questions that sometimes they have 5 possibilities to answer about. So the total amount of those data are the raw data. This is very simple. And what we are talking about, some kind of prepared data that can make this applicable, usable, immediately transparent, something that is really for let's say, play the role that they have to play, which is use the data to improve services that you can give on the side to help innovation, to help researchers, and so on and so forth. So this pre-prepared data is the concept. So this is because you want to an agreement and you say, no, I want the raw data because I will start and will discover and this and this and that. And I just prefer to have the raw data. That happens in other areas many times. Researchers prefer to have the raw data and then work with the raw data, not so much with the more pre-prepared data. But this is a more, let's say, it is another kind of sector that we're talking about. And then the transparency, the clean data, and all these kind of things that can help to an immediate way of using those data, I think is important.
Thank you. To be quite esoteric, I guess data or information isn't always knowledge, and we're talking about a knowledge-driven economy. And I know, thank you, Pilar, for pointing out everyone. I'm pretty sure all our Euractiv viewers are very familiar with the lawmaking process in Brussels. It's not straightforward and takes time. But of course, it does allow us debates like this at this juncture before everything is set in stone. Keir, let me come back to you. We've got a lot of points on the table there. What would you like to raise, or what changes would you like to see?
I would like to see a couple of changes with regards to how to bolster the European digital economy and EU small businesses. I think I would love to see two steps. One is we remove the carve-outs from the proposal, and then two is we find a way to reduce the compliance burden, all of which the end goal to be, I want to make sure that IoT businesses can enter and operate and innovate as successfully as possible in the EU market. And I think a long-term solution that removes the carve-outs based on size distinctions and maximizes the incentives to share data could succeed there. That is a very abstract change that I'd love to see, and it could come out in a bunch of different ways. The one main thread through all of those is going to be removing the carve-outs. From an international perspective, I'd love to see some clarifications on cross-border data flows and data accessibility. I know that's not necessarily the main question of this presentation, but I think having a revision of that space could lay down the foundation for the European data economy and European SMEs to be innovative competitors and innovative heavyweights internationally, which would make IoT startups in Europe get off the ground quicker, faster, and compete with high-tech markets like the US, UK, and India.
Thank you, Keir. I should say, of course, Pilar had to leave us a little bit early, but we are very grateful for her input, as she is a rapporteur and she's an extremely busy woman, so we appreciate the time taken out. Antonio, I think you had a couple of comments that you wanted to raise in relation to what we're talking about.
Yeah, unfortunately, it was actually related to Pilar's comment regarding the prepared data and raw data, and I would just really like to piggyback on that. But unfortunately, she left. But nevertheless, I'm sure that one way or another, she'll get the message. So it's actually very much in line with the intention that we had when we first proposed the Data Act, because of course, raw data, as the rapporteur was explaining, these are kind of like automatically generated data points. And it's also known as source data or primary data, among other technical nomenclature. However, raw data in and of itself, of course, has limited value. And this is also quite complicated because nowadays, the more that you see the algorithms going directly to the data and the data being cleaned or transformed as soon as it's generated, it kind of brings the question, how can we exactly ensure that we respect the proprietary investments that data holders are doing to ensure that this product or the provision of the service takes place, but actually, and also at the same time, we want to ensure that data goes out into the market or into the user's hands, potentially already in a usable format. And so that is essentially what prepared data is. So we want to ensure that in situations where this automatic and often immediate cleaning or categorization or classification of the data takes place, this data is still captured by the Data Act. And so it's also, we also want to ensure that we're not leaving out vast amounts of data that are actually easily and readily available to the data holder. So this is the idea. Of course, there can be further refinement, but what the rapporteur was suggesting is definitely in line with our own intention.
Thank you. Let me bring you back in, Thomas, in terms of, do you have any perspective on these different types of data that we're discussing and whether we need clarification?
Yeah, I would like to come back to the example with the machine, and you have been talking about raw data. If there is a clear specification requested from the producer of the machine, what kind of operational data this machine can deliver, then the possibility is given to work with all that data. So the user has the possibility to retrieve the data, but there is no obligation to use every kind of data which could be delivered at the same time. As I did understand, you say this machine is delivering a specific set of data, of operational data, the user of the machine can work with. And maybe the user has the wish to process that data on another place to get out additional information, additional value. And this is exactly the point where we need more transparency on the kind of data which has to be delivered on the operational interface. This is the point which is somehow not that clear at the moment. I believe that if the obligation is pushing the European Union machine producers to specify their operational data interfaces, and if I'm looking to the international market, and a customer, an international customer, has the possibility to buy the machine from two vendors, and one vendor is giving a clear picture about the operational data which could be retrieved from that machine. The machine is from a European Union manufacturer, and on the other hand, another manufacturer from somewhere in the world giving no information about that it's very likely, based on the data business which could be done out of that operational data, that the customer says, okay, I would like to buy, if the machines are equal in all the other aspects, I will buy this machine from the European Union manufacturer.
Keir, let me come back to you with a question from our audience that has come in. It's related to cloud vendors who do not differentiate personal from non-personal data when transferred overseas. Instead of having potentially two different sets of data transfer requirements under the Data Act and the GDPR, shouldn't data transfers complying with GDPR be presumed to comply with the Data Act?
I don't know if I can definitively say yes or no to that one, but I do think that this question highlights an interesting difference between the Data Act and GDPR. When I look at both of them, GDPR doesn't differentiate based off of the Digital Market Act's gatekeepers definition, whereas the Data Act does, because it excludes gatekeepers from being eligible third parties to receive shared data, though they can get that data through other lawful means. So while the Digital Markets Act may be GDPR compliant, I do think Data Act and data sharing in that regard, and then GDPR data portability are going to overlap in practice. What that practically looks like, I think, is going to be entirely situationally dependent. And because of that, it's going to be something that all of us are going to look very closely at. I know, at least for me, I'm quite curious to see that interaction because it's hard to theoretically define in my head until I've seen it play out in real life. And I think thinking about this conversation before we even get past to the end stage of the Data Act is really important.
A lot of what ifs still on the table, I think it's fair to say, at this stage of the legislative process. Antonio, another specific question coming in for you. Could you please elaborate on why the Commission has proposed the same data sharing regime for both B2B and B2C? Aren't there deep differences between the two? For example, exposure of trade secrets from B2B and the volumes of personal data involved in B2C.
Yes, so perhaps we can look at it from a different direction. Why should they be necessarily separate? Since many of the issues that we find in B2B relationships when we're talking about data sharing also exist when we're talking about B2C. So legally speaking, there wouldn't be necessarily a difference other than perhaps a completely new chapter that looks pretty much like the first one. So if we can combine both, and again, because we see many of the same issues happening in different constellations, although this is not to say that the solution is the same every time, which is not the case, but there are specific parts of the Data Act that deal specifically with B2B issues, Chapter 3, for instance, and others that deal with other kinds of relationships, B2G in Chapter 5, when we're talking about, businesses making data available to public sector bodies under exceptional circumstances. So it really depends on what we're talking about here. There isn't a necessity to have this split unless we start talking about specifics.
Thomas, let me ask you a sort of a leading question. If we're going to talk about this sort of interaction with sectoral laws, what sectors are we needing to think about? And in terms of that as well, what sort of breakdowns of different sectors are we needing to think about? One of our questions is asked, how can the Data Act be linked to the 4 sectoral data acts expected, vehicle and related data, health data? And we're also specifically today thinking about SME manufacturers. Where do they fit into this whole complicated jigsaw?
Let me highlight one sector, which is really having a huge profit on that Data Act. Let's go to the critical infrastructure. I'm in touch with a lot of other CISOs being responsible for critical infrastructure, and they have one specific problem which should be addressed. We are talking about data, we're talking about transparency, but we should also talk about communication channels. What about unwanted communication and the obligation to have transparency about what data is transferred over which communication interface? And also the point that the communication interface has to be specified and clear to the customer buying that system. That's one of the points. So I'm addressing unwanted functions. And if we have the Data Act, we can say we would like to have transparency on the communication channels and the data, which could be delivered from that specific component or machine or health device, whatever. So this is something which would be really important from the information security point of view, because this obligation will affect all manufacturers delivering products to the European Union.
Thank you. Again, obviously, we have more questions for the Commission. A couple around the gatekeeper prohibition, suggesting that it's locking users into services. Is there a middle ground to be found? Antonio, perhaps you could expand a bit on this topic. I know we've only a few minutes left, but if you can give a brief overview of the thinking.
Yes, of course. So indeed, I'll keep it relatively short. The reasoning for the exclusion of gatekeepers as eligible third parties is actually in line with many of the other proposals that we, of course, well know that the Commission has been putting forward for the past few years. This is essentially of ensuring, for example, about a level playing field. We want to ensure that in a very perhaps pithy way that the data doesn't keep going to the data rich. We want to ensure that those who have lack of data, that are data poor, actually get data. So we want to boost that sector, and specifically dealing, for example, with SMEs or even larger companies, because otherwise you will keep having, the gravitational pull that gatekeepers, due to their nature, really keep receiving more and more data. And therefore, since this, as I mentioned earlier, data will be the infrastructure of the future data economy, we really have to ensure that more players in the data market actually get this data. So that is the thinking behind this exclusion or this exemption of gatekeepers as eligible third parties. But as Kira actually mentioned earlier, this does not mean that gatekeepers cannot get access to, IoT data by concluding or celebrating data sharing contracts directly and voluntarily with data holders. They just cannot rely on the mechanism that will be put in place by the Data Act under Article 4 and 5. So that is the crux of our thinking with regards to the gatekeepers in the Data Act.
Well, we'll see what happens to that through the Parliament and the Council discussions as well. Any last comment, Antonio, from you before I ask our other panellists, because we're going to wrap up now?
Well, very shortly, actually, it was a really pleasurable discussion. I hope to talk to you again very soon. Thank you so much to Euractiv as well for the invitation, and to you, Jennifer, for the moderation. And just to emphasize, we are today at a pivotal time in the data economy, and we really need to seize this opportunity to boost Europe's leadership position in this regard. So thank you.
Thank you. I think we're all united on the aims. It's how we get there is the question. Keir, final thoughts from you?
Well, first I want to thank all the other panelists for their insights. It's been really interesting hearing everybody's different points of view on this legislation. If I could emphasize anything, it would be that narrow adjustments and clarifications in the Data Act can ensure that companies treat the European market as a more friendly market internationally, and also ensure that data-driven innovation really thrives in the EU. I think if that's the goal of the Data Act, I'm so looking forward to seeing the conversations and the evolution of this legislation, because with some adjustments here and there, the Czech presidency has given a couple that I think are quite nice. We can see a European data economy that is innovative and competitive internationally, and is also able to get incredibly high quality IoT startups off the ground.
Well, that's the hope. And Thomas, final word or final closing thoughts from you?
Thank you very much for inviting me and for your professional driving us through the discussion. It was a valuable discussion for me. And transparency is one of the benefits, but protecting the IPRs of the existing manufacturers, that's one of the goals we should have. We should not give up the advantage we have in the market. So we should see this Data Act as an instrument to get more advantage on the international market, but also protecting the IPRs for all the manufacturers. And state of the art. Cybersecurity should always be part of all the data operations we do.
Absolutely. Thank you very much, Thomas, Keir, and Antonio, and of course Pilar, who was with us there earlier. And for you, the audience, for sending us in some very tricky questions. I'm sorry we didn't have time to get to all of them. As is always the case with a new piece of legislation, there's a lot more questions than answers at this stage because we don't know how it's going to end up. But we at Euractiv will, of course, be following that along throughout the entire process. Thank you also today to VDMA, who are behind today's event, and we hope to look closely at the sectors that we've raised today in future debates to come. Remember, you can follow using that hashtag EA Debates for more on Euractiv. With that, have a great day.